Hey, can we talk about how to deal with real life stuff here for just a minute? Hi, I'm Ann at Hart Law PLLC. I'm an estate planning attorney in Washington State. In a perfect world, you'd handpick your family, your friends, and others important to you, maybe a charity or two, to receive your assets after you die. And then your personal representative would make those distributions according to your wishes. The reality is that life can get really messy, filled with ex spouses, estranged kids, blended families, friends who've fallen out of favor, addictions, and so on. In other words, the people that you select as your beneficiaries when you're 30 may not be the same people you want to get your stuff 50 and 60 years down the road. Plan to review and or update your beneficiaries for all of your financial assets annually, or at least every 2 to 3 years in good practice. And here's why. A fellow attorney was sharing with me a case she's been working on recently. A woman had died after a very long and rewarding life. She and her husband worked hard, saved their money, and lived very comfortably. They were smart and they had an estate plan drawn up when they were still fairly young, about 30-ish. They had a young child at the time and had a decent amount of assets. They named a personal representative, a guardian for their child, and specified that their son was to get their assets after they passed away. And then they never touched it again. Decades went by and the family assets grew to an astounding size. The husband died before the wife, and then the personal representative died, and then her son died, and he had no kids. And then finally the wife died. Probate was open to determine who would be named as the personal representative for the estate and to determine under Washington state law where the couple's assets should go. And while I'm happy they had a plan drawn up, it was only usable for a short amount of time. They should have revised their plan after their personal representative died, and the wife certainly should have revised it after her son died. By the time she died, the conditions in the plan were absolutely impossible, and the court reverted to statutory state law for distribution if she'd had no will at all. Here's the rub. If she'd made updates to her estate plan, she would have named another personal representative and a backup, and she would have redirected her fortune to a place of her choosing should her son predecease her. But that's not what happened. But I'm going to tell you the rest of the story in my next chat. But if you have a plan that's more than 4 or 5 years old, please have somebody like me review it for you. If you don't yet have a plan, you really do need one, and you need to maintain it. Don't let time and major life events go by while your plan goes stale. So call me. I'm Ann Hart, Hart Law PLLC, your attorney with Hart. And stay tuned. I'll tell you the rest of her story in tip number 7.